All right, back on the record. This is the people of the state of Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Mr. King, is this a good time for me to go over the Curtis advisement again with your client?
Yes, Your Honor, and Ms. Brady is seated next to Mr. Holmes in case he has any questions to deal with that.
Okay. All right. Mr. Holmes, I need to speak to you directly at this time. If there is anything that I say to you that you do not understand or do not hear clearly, please let me know. I need to advise you, Mr. Holmes, that you have a right to testify in this trial. If you want to testify, no one can prevent you from doing so. You may take the witness stand and testify even if it is contrary to the advice of your attorneys. If you want to testify, no one can prevent you from doing so. I think I mentioned the first time I went through this advisement with you that you're represented by 5 excellent attorneys, and it's a good idea for you to speak with them about this. But in the end, it's your decision, and it's a personal decision, and if you want to testify, no one can prevent you from doing so. If you were to testify, then the district attorney would be allowed to cross-examine you. If you've been convicted of any felonies, the district attorney would be entitled to ask you about those convictions and thereby disclose those convictions to the jury. If any felony convictions are disclosed to the jury, I would instruct the jury that it can consider them only as they bear upon the issue of your credibility. I would instruct the jury that it cannot consider those felony convictions for any other purpose. The last time I went over the Curtis advisement or this advisement with you, which was a couple of weeks ago, I asked the district attorneys if you had been convicted of any felony convictions. And my recollection is that they indicated that you have no prior felony convictions, but I am going to check with them again and have them confirm. Mr. Orman?
You are correct, Your Honor. We are aware of none.
Okay. In this case, jurors are permitted to submit written questions that they would like to have asked of witnesses. The same rules of law, including the rules of evidence that apply to attorney questions, also apply to juror questions. The court will not permit improper juror questions to be asked of a witness. If you decide to testify, and if the jury submits one or more questions that the court determines are legally proper to be asked, you will be asked those questions. And Mr. Holmes, you've seen the process that we have followed throughout the trial in terms of allowing the jury to ask questions of witnesses who testify. We would follow the same procedure if you decided to testify and to take the witness stand. We would allow the jury to submit questions. I would call counsel to the bench. We would discuss the questions at the bench during a bench conference outside the hearing of the jury. I would listen to any objections, and I would then determine what questions, if any, are appropriate to be asked. If I decide that any questions are not appropriate based on the rules of evidence and other rules of law, I would not ask those questions. If I determined that any questions are appropriate, then I would ask those questions, and then I would give each side an opportunity to ask follow-up questions based on those questions, starting with your attorneys. The same process that we have followed with all witnesses who have testified in this trial. I have mentioned to you now that you have a right to testify in this trial. I need to advise you that you also have a right not to testify in this case. You are protected by a constitutional provision against self-incrimination. Therefore, you do not have to testify if you do not wish to do so. If you choose not to testify, then the jury will be instructed about that right, and that no inference of guilt can be drawn from the fact that you chose not to testify. Let me read you the specific instruction that I intend to give the jury. The instruction reads as follows. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. If you chose not to testify, that's the instruction that I would give the jury. The decision of whether or not to testify is a decision that must be made by you and by you alone. As I mentioned a moment ago, it is a personal decision. I mentioned to you that you're being represented by 5 experienced, excellent attorneys, and it's a good idea for you to talk to them about this and to hear their advice. But in the end, this is your decision, and it is a personal decision. In this case, you've been advised and represented by Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler. Have you discussed with any of them or all of them whether or not you will testify?
Yes.
Have you had enough time to discuss this matter with them?
Yes.
Do you need more time to talk to your attorneys about this matter?
No.
Have you made a decision as to whether or not you will testify?
Yes.
And what is your decision?
I choose not to testify.
Is that a voluntary decision?
Yes.
Is that a decision that was made as a result of pressure or influence or threats or promises or coercion?
No.
Do you have any questions for me?
No.
Do you understand both your right to testify and your right not to testify in this trial?
Yes.
Is there any other record that the people want me to make or any other questions that people want me to ask?
I think just to clarify, Your Honor, you indicated, I think, before you read the instruction to the defendant that it would be his choice or his and his attorney's choice about whether it would be read. And at the end, you said, this is the instruction I will read to the jury. I think it just needs to be clear that they have that choice and it won't be read automatically unless they decide it shall be read.
You mean the instruction that I would give the jury if he chooses not to testify?
Correct, Your Honor.
Okay. Did you understand that, Mr. Holmes? The instruction that I read a moment ago that I would give the jury in case you choose to not testify and you're saying that you've chosen not to testify, I will give that instruction to the jury. But if your attorneys object to it and ask me not to give it, then I wouldn't give it in that situation. Do you understand that?
Yes.
But if there is no objection from you and your attorneys, then I will give that instruction. Do you understand that?
Yes.
Okay. With that understanding then, does that in any way change your decision in this case as to whether you will testify or will not testify?
No.
And is that still a voluntary decision?
Yes.
And do you have any questions for me?
No.
And do you still understand both your right to testify and your right not to testify in this trial?
Yes.
Mr. Orman, is there any other record that the people want me to make or any other questions that people want me to ask?
No, Your Honor, thank you.
All right. Any other record that the defense wants me to make, Mr. King?
No, Your Honor.
Any other questions that you want me to ask?
No, thank you.
All right. Mr. Holmes, do you have any questions at all for me?
No.
All right. Based on the record made here with Mr. Holmes, I find that his decision to not testify is one that has been made knowingly, voluntarily, and intelligently, and one that has been made after he spoke to his attorneys about this, and one that he has made personally. All right, is there anything else we need to talk about at this time? Oh, I know there was one thing, Mr. King. I think you were going to tell us what type of time warnings you want for closing arguments. Do you still want to wait until tomorrow to tell us that, or?
I think if I could get 30 minutes and 5 minutes, please.
Okay, 30 minutes and 5 minutes. Anything else at this time? No?
Nothing from us. Thank you, Your Honor.
Anything on behalf of the defense?
No, sir.
By the way, the statute that I mentioned earlier in terms of keeping the alternates sequestered is 18-1.3-1201, subsection 1A, just so that the record is complete. All right, folks, I'll see you tomorrow at 9 tomorrow, so you get to sleep in a little bit. All right, the court will be in recess. Thank you.